All right, again, that was some of the prosecution's opening statement. Let's talk a little bit more about it with my very special guest, Law and Crime trial analyst, Jonna Spilbor. Jonna, good morning to you.
Good morning, Jesse.
Let me ask you, this case feels different. We've covered a lot of police shootings. A lot of times, white police officers, black victims. How does this one differ? Because I feel it's different. What do you think?
There are a couple things that stand out for me. Number one, and what I think the prosecution is really hanging its hat on, is the sheer number of bullets that this police officer shot into this victim. That's number one. Number two, we don't always get a real-time video of exactly what was happening. Like, we get to see it through the officer's perspective, and that's huge because one of the problems for the defense in this case, Jesse, is this officer shot this victim after he was no longer a threat, and that's a big issue in terms of this prosecution.
The prosecution said he didn't know any of the facts. The defendant didn't know any of the facts about what Laquan McDonald was really doing that night. He just saw a black boy walking down the street and had the audacity to ignore the police. What do you think of that statement? Well,
obviously they're making it into a racial argument, but what he failed to mention is there was a weapon in this victim's hand, and I think that's going to play into the defense quite a lot.
But again, a knife walking away from police and there are no civilians there.
I know, but the defense is going to have something to say about it. You can bet that.
Well, I think this is a pretty big day for them, and we're going to have to see which way they go. Now, we've been analyzing about where the defense may take this case, but let's try to get a glimpse of it. Again, let's go back to their opening statement. And remember, their narrative of what happened is entirely different from the prosecution. Take a look. All right, you're getting a glimpse into the defense's strategy because they take up the case today in the Jason Van Dyke trial. We'll be live there today. Back here with Jonna Spilbor. Okay, let me ask you this, all right? We can't deny the fact that Laquan McDonald was breaking the law.
Right.
And he didn't obey police directions. Right. Having said that, what would you say the argument, that doesn't give the license for officers to always use force whenever somebody disobeys their orders or is breaking the law? Because if that was the case, police officers would be shooting everybody all the time. This is that argument really effective?
I think what we will see in the defense case is they're alluding to something here, because I was surprised by what I just heard, Jesse. When you say that, of course, it's not usual for let's call him a suspect at that point, to be walking away slowly from the police when the police are saying, stop, don't move, whatever. They want to arrest him, they want to talk to him, detain him, what have you. So yes, that is unusual. But if you ask the prosecution, that's no cause to put 16 bullets in somebody. So I'm going to guess that the defense is going to say maybe they were trained, that when a suspect starts acting strangely, you got to put one hand on your pistol.
You can have a hand on a pistol, you don't fire. I mean, really, every time I've seen these cases, look at the other officers, right? None of them open fire.
Which is true, and listen, we have to see what the defense is going to give us when they start the testimony later today. But something must have. This officer wants people to know that this was not a premeditated killing; that he was in fear for other people's safety as well as his own.
30 seconds. Do they put him on the stand? Do they put Jason Van Dyke on the stand?
They have to. They absolutely have to. We need to hear from him what was going through his head.
I'm glad you said that. We had a guest on Friday who said they're not going to put him on. I like this discrepancy. We never know which way it's going to go. That's what I like about this. So as we wait for the live feed, we have a lot to analyze, including the testimony of a use of force expert. We'll be right back right after this. Okay, we have to talk about what the defense is going to do after such really powerful testimony. Back here with Jonna Spilbor.
Yeah.
When you have these experts, this is what they specialize in. They're not being called to say what their favorite color is. You get this guy on, seems very credible. What does the defense do to combat this? Bring in their own use of force expert?
Exactly. When you have a hired gun, which is what an expert is basically, you're paying him to give an opinion that's favorable to your position, and guess what? The defense gets to bring in their own expert to do the exact same thing. So then it becomes a battle of the experts.
Let's break down the factors. I mentioned them before. The factors in favor of the prosecution, the taser unit was in the area, Laquan McDonald was walking away from the officers, there were no civilians in the area, no other officers fired their weapons. What are the factors in support of the defense then?
Okay, so what we anticipate, I suppose, is number one, He was a police officer on duty. He saw a threat. I mean, would it change your mind at all, Jesse? What if this officer takes the stand and says, I did not believe that was a knife in this victim's hand. I thought it was a gun. I thought it was a small gun.
Then he needs to get on the stand and explain
He's going to have to explain that. And I think that will change this game a little bit.
Now, I don't know which way this jury will go, and I don't know what is right or wrong here, but what I do know is this is appropriate questions to have, because when you have no other officers firing their weapon, and he puts 16 bullets into this kid who was just carrying a knife, even if he knew it was a knife or whatever, a gun versus a knife, does that make sense to you?
Well, that's the whole point of the prosecution. I think at some point, if he had put 1 or 2 or 3 bullets into this unfortunate victim, would we have a first-degree murder trial going on right now? Maybe not.
Well, we will have to see, and there's a lot more I want to talk about the number of shots fired, but when we come back, there were some issues surrounding that dash cam footage. We'll be right back. Okay, so that's a common defense tactic, I think. Let's bring back in Jonna Spilbor. Am I right? Is that a common defense tactic when you have such a strong video to say, hey, what about the color scheme? What about smudges? Are there things that are caught in the that are not caught by the camera?
Yeah, I don't know if it's so much like an overall tactic, but perhaps in this case, it's a little foreshadowing of where the defense intends to go. There might have been something in the purview of this particular defendant that we're not seeing on this dash cam video that's going to be important. So what this defense attorney is doing right now is priming the pump so the jurors are open to that.
Does this work with the jury?
It's going to depend. And again, I think it's going to depend on what's going to come out of this defendant's mouth, which means his mouth is going to have to be on that stand telling a story at some point this week.
I think that's hilarious the way that you said it. Just his mouth. His body can take a seat, but his mouth can be on the stand.
He's got to talk because his perspective is probably not identical to what this video is showing. And one thing that came out, I'm watching that video with you in the replay, and I'm wondering, were there any bystanders in danger if this particular victim had a weapon, whether it's the knife or whether it was a gun, whatever he thought it was? Were there other bystanders in danger?
The prosecution has said that there were no civilians nearby, but let's see from what the defense ultimately does. Now, we talk about the dash cam footage. There was a big controversy with one of the witnesses that talked about that, and that was Mark Messick, a forensic video examiner. We'll play you his testimony and talk to you about why it was eventually thrown out by the judge. Take a look. Here's the problem. This witness is a forensic video examiner for the FBI, not a ballistics expert. So when you hear this conversation about how many shots were fired, where they hit, it's not really his specialty. This was thrown out by the judge. I want to get a reaction now from Jonna Spilbor. The jury heard all that.
Yeah.
So now they had the judge comes and says, jury, disregard everything you just heard, including him saying, hey, my name's Mark Messick. Yeah. Is that a realistic thing? Can the jury actually forget it?
It's problematic. No, the jury's not going to forget it. They heard it already. You can't unring the bell, so to speak. And I'm wondering if maybe it could have or perhaps will form the basis for a request for a mistrial. But I think the defense actually made a couple points, even though the testimony is getting thrown out. What the jury did here is I'm wondering if the defense is going to argue that this police officer didn't know he actually hit the victim 16 times.
And how would that help?
Well, because the argument on the prosecution end is 16 times. He hit him, shot him 16 times. That's far too much. And if this officer said, I thought I hit him only once and the rest of my bullets were going someplace else, and he was justified in using some level of force, that may help in his defense.
Tying into that, we've had a discussion last week about use of force by officers. When they see a threat, they have to do what they have to do to put that threat down. Meaning maybe unloading their entire firearm, maybe reloading.
Right.
What would you say to that argument, and would the defense exploit that?
I think they're going to have to. I mean, people want to argue that there's no such, cops are not trained to shoot to kill, and I think that's a false argument. It's called deadly force for a reason. They don't shoot to maim, but as you said, their job is to stop the threat. This officer is going to have to testify that he was stopping a threat.
Well, he might not have been a ballistics expert, but when we come back from our next break, we're going to hear from the ballistics expert and talk about those puffs of smoke. We'll be right back. This breakdown of how Laquan McDonald was shot is crucial to this case, and we're going to talk about it a little bit more. But here on the network, we are also eagerly anticipating our new case of Jessica Chambers, the retrial of Quentin Tellis, the man who's charged with burning this 19-year-old girl alive. He is facing a retrial after his first trial ended in a mistrial, and we here on Law&Crime are going to cover it. But before we do that, let's break down why this case may be different moving forward. Back here with Jonna Spilbor. Jonna, question. What does the prosecution and what do the defense have to do differently this time around to get a verdict?
I'm a bad person to ask, and here's why. Was completely surprised that there wasn't a guilty verdict the first time around.
Really?
Yes,
there was evidence pointing the other way.
No, because here's why I thought, I mean, listen, there was enough evidence to put this defendant, at the scene of the crime. The thing that people were hanging their hat on there that I completely disagreed with was when she allegedly made a dying declaration that somebody else did it. And my whole philosophy is, the woman was dying to death. She was burnt all over her entire body. Whatever came out of her mouth is not reliable enough to hang a conviction for somebody else on.
You might be 100% right. No one knows what was going on in her mind and what that state was like. It was a horrific, horrific scene. But for her to keep saying Eric, or what sounded like Eric or Derek, to a lot of different people is questionable. I know we only have 20 seconds.
Yeah, I still think, I think the prosecution doesn't need to do anything different. Except pick a different jury.
Well, they're definitely going to get a new jury, and this is something you're definitely going to want to watch. In the meantime, before we go to our next break, here's our very own Aaron Keller talking a little bit more about this very special and interesting case. Take a look. The testimony from officers that night is crucial, but one of the things that you can't forget about, and that's hanging a dark cloud over this entire case, is the fact that multiple officers were charged with conspiracy to cover the shooting up. Back here with Jonna Spilbor, that's a big thing that makes this case different.
Yeah, it does, because it...
Excuse me.
God bless you. It makes the defendant look even more guilty, because if you didn't do anything wrong, there would be nothing to cover up.
His former partner testified against him, was granted immunity in exchange for that testimony, and talked about that, yes, he fired his weapon, I could have fired my weapon, I didn't fire my weapon, and he kept firing when Laquan McDonald was on the ground. So when you hear this, if you're in the jury, and I don't think they know about the conspiracy charges or anything like that, and they hear these officers who are coming forward and not protecting one of their own, but saying, he fired his weapon, and we didn't do it. What's the defense going to do?
The defense, they're going to do the one thing that if I'm wrong, I will eat my shoe in Macy's window. This defendant needs to testify. He's got to let the jurors know what was going on inside his mind, and let them also know that it wasn't a premeditated murder because he was in fear for his safety, other officers' safety, bystander safety, whatever was going on from his perspective.
I imagine the idea of saying, well, I was trying to protect my brother officers is a big thing the defense will want to exploit.
Yeah, of course.
More so than I was trying to protect myself.
Of course. I mean, you know, this is Chicago after all. Chicago has a bad reputation in terms of its crime. So these officers maybe have a little different mindset than you do if you're in Oshkosh, Iowa.
Right. All right, well, we've been playing the testimony from this officer, but this is not the only witness to the shooting. Here's Xavier Torres, who explains what happened.
And you said that you saw Laquan McDonald walking.
Yes.
Where was he when you first saw him walking?
He was in the middle of the street.
What street was that?
Pulaski.
Okay. And was anything blocking your view of him?
No.
Okay. What did he do after you first saw him?
I just seen him walking southwest towards the fence.
Okay. Now, you described the fence. Where is that fence located?
The fence is located on the opposite side of the street from where we were at. We were heading northbound.
Okay. And how tall was that fence?
I'd say it's about like 6 feet.
Okay. And was there anything on the fence?
Yeah, there's like a green tarp, I believe.
So it's like a chain link fence that has a green like construction tarp over it?
That's correct.
Okay. Now, you said that Laquan McDonald was walking southwest. Was that directly in the direction of any of the police officers on scene?
No.
Could you describe how he appeared when he was walking?
Yeah, he just had like just kind of a weird walk, just walking away from the scene.
Okay. And when you say a weird walk, could you just describe it?
Just like a hop to his walk, kind of.
So it's a little bouncy?
Yeah.
At some point, do you hear gunshots?
Yes.
Okay. And where is Laquan McDonald when you hear gunshots?
It was towards, it's kind of when he was walking towards the fence.
Okay, so he was walking in the southwestern direction?
Yes.
And you hear gunshots?
Yes.
What happens after you hear gunshots?
After I hear gunshots, I just see him, just fall to the ground.
One of the great things about the trials that we cover is when the prosecution goes first, you say to yourself, wow, they're really building a strong case. I can see how the jury would come back with a verdict of guilty. But we're waiting for what the defense will ultimately do today. So I'm here back with Jonna Spilbor to talk about it. And what kind of witnesses would the defense ultimately need to bring in to switch the view of the jurors? What would be the ideal witness besides the defendant himself? What ideal witness would you have come forward?
Well, we know that they have to bring in an expert to counter the prosecution's expert, because that's what you
Use of force expert.
Yes, you have to do that. And then the other most important witness is going to be the defendant himself. And I don't know.
Well, what about eyewitnesses that night, or people that knew Laquan McDonald? Do you bring them in?
So part of the argument on the prosecution's case is maybe Laquan McDonald was not a great kid, but this officer didn't know that at the time that he emptied his gun into him. So perhaps there is room to counter that. Maybe the police officer had a personal relationship with Laquan. Maybe he knew that there was a lot of, that Laquan wasn't a model citizen, and maybe that's going to matter. So he's going to have to testify to that too.
I'm not sure of this. Do you think that they could bring in a witness, an eyewitness who maybe saw something that would give a radically different view of what happened?
Well, I guess we're going to find out, because so far everybody else has testified very consistently, so that could be almost problematic for the defense here. But if you have one person who says, no, I saw him pull out a gun, and everybody else said, no, I didn't, the jury's going to have to really weigh that.
And then at the end of the day, defense may call one witness, the defendant, and that's it. At the end, isn't it really they can win or they can win or lose this whole case based upon their opening statements and their closing arguments if you're the defense?
Closing arguments are powerful. I think they're more powerful than opening statements, so we'll see. But the prosecution gets the last word because it's their burden, and they've got a pretty good case.
They do have a pretty good case, but we're waiting to see what will happen. When we come back, we're going to talk more about that dash cam footage, the most important piece of evidence in this entire case, and we'll update you about the other trials happening across the country. We'll be right back. Welcome back, everybody. We're talking about the Jason Van Dyke case. We're waiting for that live feed, and today's going to be an exciting day where the defense begins their case. Now, Jonna, we keep talking about having the defendant take the stand, which may be a very good idea in these kinds of self-defense or defense of others cases.
Right.
What is the worst thing that could happen if he takes the stand? If he comes off a certain way, what would be the worst thing that we can look out for?
You know, that's really, really tough, because before any defendant takes the stand, his or her attorney sits down with them to let them know, I'm not going to call it coaching, but of course they're going to kind of practice what they're going to go over. And if you get a sense as a defense attorney that your defendant, your client, isn't going to make a good witness, you have to rethink the decision to put him on the stand. So I'm going to surmise that if he ends up on the stand, he's going to be cool as a cucumber and simply explain from his perspective. He's a cop. He was a pretty seasoned cop. So he's going to have to explain what was going on in his head.
Let me ask you about that. One of the things that we know, the jury doesn't know, is that during his long career, he's had multiple complaints filed against him, and even a lawsuit, judgment was rendered against him based upon his actions. We've seen very forceful, aggressive conduct, and even accusations that he used racial slurs. How could the jury hear evidence of that? Is it if the defense opens that door up?
Typically, any time that you take the stand, your credibility is an issue, so the jury will likely hear about that no matter what he says. In other words, it's going to be fair game. But in this particular case, I think the defense attorney is going to have to parse it out and say, you're not judging him for that. We're not here for that. We're here for what happened on this particular night when Laquan McDonald was killed, and was it justified or not, and listen to my client, what was going through his head at that time when you make your decision. Well, it's going to be tough.
If he takes a stand and that evidence comes in, That's huge for the prosecution, I'll say right there. All right, let's play you now some testimony back to Mark Messick. Remember that FBI forensic video examiner whose testimony got thrown out? Well, there were some good things that were let in, and I want to play some of that testimony right now because it's important to hear his analysis of that video. Take a look. The stakes of this case cannot be overstated. I mean, really, there is so much to talk about here. People are watching this case. The jury room, the courtroom, excuse me, is packed. We had the Reverend Jesse Jackson on Friday to talk about it. He's been there. Jonna, let's talk about this, okay?
Okay.
There's a lot riding here. What is going to happen if this man is found not guilty? What would realistically happen in Chicago?
Well, now you know that there is a large contingent who already believes he's guilty. Maybe he is. We don't know. So I don't think those people will take too kindly of it. But, you know, you also have to look at the other side. This is a police officer who went to work and now is facing first-degree murder charges. If he is guilty, and he very well may be in the minds of the jury, that could really have a chilling effect on all police officers, right? You don't want, if a police officer is protecting me and you, Jesse, I don't want them to hesitate using necessary force because they don't want to be facing a murder charge.
I read an article that the Chicago Fire Department is already preparing for the verdict. I mean,
oh boy,
this is a pretty scary situation.
It is.
If either which way you go.
It is, and don't forget, I think this defendant has the worst jury he could possibly have for this case. He's got one of his jurors has a relationship with somebody who has a relationship with the deceased.
Explain that to me.
I don't think that.
Explain that.
So there is a juror who is in a relationship with somebody who works for family services, with the equivalent of what we call it here is family services, who was a caseworker for Laquan McDonald. Now, I'm sure that that person is quite upset that her former client is dead. He was a young teenage boy. How could this juror who lives with that person possibly be fair and impartial?
How did that person get on the stand? How does this happen?
Because when the defense made a challenge, a peremptory challenge, or challenge for cause, the judge said no. They were out of peremptory challenges. That person stays.
Sometimes the law just doesn't comply with common sense.
Or does it?
Or does it?
Or does it?
Back here with Jonna Spilbor. Does the law make sense? All right, everybody, here's what we're going to do. We are going to take a break. We're carefully looking at that courtroom feed. As soon as trial starts up, we're going to start up. But when we come back, there is so much more to talk about in this case. So stay tuned here on Law and Crime. All right, every piece of evidence in this case is critical. It's not just the dash cam footage, but also the clothes and the crime scene tell a story. Jonna, our Law and Crime trial analyst right now, what's going on here in terms of why is this important? And you see the victim's clothing. What does that tell you if you were the prosecution or they're trying to tell the jury?
You know, I honestly don't think it's that critical, because really what it is just telling the jury stuff that is not really going to be contested, such as there were 16 shots fired. I don't think the defendant is going to say, no, it was only 15. There's an errant casing somewhere. That wasn't mine. Like, I don't think that's going to be the case. So the prosecution is just methodically moving through exactly what happened. 16 shots were fired. Here's where it hit him on the body. Here's where it hit him on the clothes, etc.
Because sometimes we forget that there's no evidence in the prosecution's opening statement. So they say you got shot 16 times. It was pretty brutal, but they have to back it up with the evidence.
With the facts.
And that's really the facts. So some of this is technical.
Right.
The bigger question, though, is the alleged slashing of the tire. That's a big point for the defense. If they can show, which the prosecution is showing as well, that he had a knife, he used it against the officer's vehicle.
Right.
That's a threat, even though that happened at an earlier moment.
Yeah, so I don't think it's a pivotal moment for the defense, and the reason is this. Slashing a tire, okay, it shows that he's defying authority. The cops are telling them to stop. He's acting kind of strangely. We later find out he had PCP or whatever in his system. Okay. But imagine take the cops out of it. If a person's on your property, Jesse, and he slashes the tire of your Mercedes-Benz or whatever it is you drive, and are you going to be justified hanging out your bedroom window with your 9mm and shooting him because of that? Oh, no, you're not. Oh, no, you're not.
No, I won't be. And thanks for giving me credit
for
thinking that I drive a Mercedes-Benz. You know, we're doing good here at Law and Crime. But all right, so maybe that's not the biggest case. But as soon as the jury hears the fact that the victim had PCP in his system, was acting erratically, and had a knife in his hand, is that enough to convince one juror, hey, you know what? Officers can do whatever they want to do?
Very well could be. One juror, if one juror says, this guy posed enough of a threat that I'm okay with an officer using deadly force, then it doesn't matter that there were 16 bullets. The fact that he was justified using deadly force will be enough in the mind of one juror, or maybe it's going to be in the mind of all 12. We'll see. If
it's one juror and they can't decide one way or another, and this is a mistrial, I wonder whether or not this is one of those cases where they, they try to retry it. We'll have to see.
They'll have to.
We'll have to see. Okay, here's what we're going to do. We are going to take a break on our end, and when we come back, there's more further discussion about this crime scene from witnesses who were there. And again, we're keeping a very careful eye on that courtroom feed because we are prepared to go live today, and you do not want to miss any minute of this exciting trial. We'll be right back here on Law and Crime. All right, this is interesting because this is the defense's first witness. I'm here with Law and Crime trial analyst Jonna Spilbor. Why did they call out a forensic pathologist?
I'm trying to guess, or I'm trying to read the tea leaves. Is she going to talk about perhaps the fact that this victim had PCP in his system and how that was making him act? Maybe she's going to go in that direction because I think that's an important part of the defense case.
Okay, let's see. Let's go back live into the courtroom and we'll find out ourselves. All right, we're learning some background information about the defense's first witness. Jonna, we see this all the time.
Yeah.
You got to show the credibility of the witness.
Yeah.
You think it gets annoying for them to testify and be like, all right, let me explain why you should listen to me, why I'm legit.
You know, it's just so necessary. The problem is it's really not exciting until you get into the meat of what they're going to talk about. But it is important because when it becomes a battle of the experts, the jurors have to say, all right, you know what, I thought this one might have been a little bit of a hack, but this one had some real credentials.
Speaking of which, we covered a case where Dr. Joseph Wu, cinema constantly in these cases where he would testify in the penalty hearings for convicted serial killers or convicted killers and would say that they had a brain abnormality. His credentials were called into question. It became an issue. You don't want to be in that seat being an expert whose credibility is being questioned.
No, you don't want your credibility questioned, and you also don't want your expertise questioned. I mean, like we just alluded to, she's testifying to all of her CV basically, but we don't know where she's going with her testimony, and the prosecution has to make sure that that matches, that she's not talking out of school, that her testimony is going to match with her expertise.
First witness called by the defense. I know that they're trying to tell a story. The question is, what story are they trying to tell?
Yeah, and I think we can guess where they're going. We're going to guess that this officer, because of the actions of this defendant who was on PCP, and even though he didn't know it at the time, was acting in a way that caused this officer to believe that lives were in danger. That's where they're going with this, I think.
We'll have to see how effective it is and what they do, but you tell me, and maybe we'll talk about it after our break. Putting the victim in the blame seat is a dangerous game to play in any kind of case, especially here when you have a 17-year-old victim and who was shot 16 times. We have to take a quick break on our end, but as you can see, a lot to discuss. We'll be back live in the Jason Van Dyke case, so stay tuned here on Law and Crime. We'll be right back. Welcome back, everybody. Now, before we go to our live feed in the Jason Van Dyke case, just want to sign off our very special guest, Jonna Spilbor, our Law and Crime trial analyst. Thank you so much for coming on.
Thank you. Until I see you again, I am tuning into this case. This defense case is going to be something else.
It is. Well, thank you so much. Tune in, and we're about to tune in because this is an interesting witness called by the defense, and she was just asked if she's familiar with the medical examiner who testified for the prosecution. Let's go live.